Nation, this is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. We are now reading part 2 of Justin B's lawyer's response to Blake Lively's motion to dismiss. And here we go. Again, this is part 2. Section 3, Argument. The FAC states a claim for defamation against Lively. Under California law, defamation is an invasion of the interest in reputation. The tort involves the intentional publication of a statement of facts that is false, unprivileged, and has a natural tendency to injure or which causes special damage. See case cited. Defamation may consist of either libel or slander. California Civil Code 44, libel is defined as a false and unprivileged publication by writing which exposes any person to hatred, contempt, ridicule, or obloquy, or which causes him to be shunned or avoided, or which has a tendency to injure him in his occupation. California Civil Code 45. Slander is a false and unprivileged publication orally uttered, where the defamation is clear without the need for any explanation. It is considered defamation per se, and damages are presumed. See court case which is cited. In an action for damages based on language defamatory per se, damage to the plaintiff's reputation is conclusively presumed, and he need not introduce any evidence of actual damages in order to obtain or sustain an award of damages. The definition of libel per se is very broad and has been held to include almost any language which, upon its face, has a natural tendency to injure a person's reputation, either generally or with respect to his occupation. See court case cited. A statement will qualify as slander per se if it charges the commission of crime or tends to directly injure a plaintiff with respect to plaintiff's profession, trade, or business by imputing something that has a natural tendency to lessen profits. California Civil Code 46. Where the defamation is not per se, and some explanation is needed to show why the statement was defamatory. The plaintiff is required to allege and prove that he or she suffered special damages, such as harm to reputation, shame, or economic damages. California Civil Code 45 and 48A. Next section. The FAC identifies specific and unprivileged defamatory statements. Lively's contention that the Wayfair parties failed to allege specific defamatory statements made by her fails for two reasons. First, Blake Lively is liable as the principal for the statements made by her agents, the Sloan parties, and Ryan Reynolds. Second, Blake Lively herself is alleged to have made defamatory statements. A. Blake Lively is liable for statements made by the Sloan parties and Ryan Reynolds under the principle of agencies and the doctrine of respondent superior. It is well settled that, under California law, one who takes a responsible part in a publication or defamatory material may be held liable for the publication. See court case cited. Skipping down to the next page. New York is in accord. A person authorizing others to speak on their behalf can be held vicariously liable for defamatory statements made by its agent. Again, see court case cited. We're going to scroll down. As alleged in the FAC, Blake Lively defamed the Wayfair parties on her own behalf and through her agents, the Sloan parties and Ryan Reynolds. An agent is one who represents another, called the principal, in dealings with the third person. Indeed, the actual smear campaign was orchestrated by Sloan at Blake Lively's direction. FAC 194. At all relevant times, Sloan parties were engaged by Blake Lively to serve as her public relations representatives and manage her dealings with the media. Blake Lively and Sloan's parties stood in an agency relationship, with Blake Lively as the principal and the Sloan parties as her agent. At all relevant times, Ryan Reynolds, too, was in an agency relationship with Blake Lively, representing her in dealings with WME and other, acting as her representative in dealing with Wayfarer and Sony. The Sloan parties and Ryan Reynolds acted as Blake Lively's henchmen in carrying out the vicious scheme to usurp the film franchise and destroy the Wayfarer parties, with the former leveraging media connections and the latter leveraging entertainment industry connections. As alleged, Blake Lively acted with and through them. Under the principles of agency, Blake Lively is liable for defamation by the Sloan parties and Ryan Reynolds. In California, a principal is liable to third parties for acts undertaken by her agents in the course of such agency that are wrongful in their nature. As used in California Civil Code 2343, acts are wrongful when they constitute an independent tort, such as defamation. See the court case cited. The Sloan parties made defamatory statements as agents of Lively, their principal, squarely within the course and scope of their agency. Indeed, communicating with the press on Blake Lively's behalf is exactly what they were hired to do. Thus, the Sloan parties acted with actual authority, or authority that the principal, Blake Lively, intentionally conferred upon the agent, Sloan, or intentionally or by want of ordinary care allowed Sloan to believe herself to possess. As the Sloan party's employer, Blake Lively is also liable for their statements under the doctrine of respondent superior. Under the doctrine of respondent superior, an employee may be held liable for defamatory statements made by its employees. See court case cited. Noting that a corporation may be held liable for defamatory statements made by its employees under the doctrine of respondent superior. Respondent superior liability is triggered if the defamation occurred within the scope of the employee's employment, even if the principal is not aware of the statement and the statement was not made for the benefit of the principal. Statements are made within the scope of employment if such statements are those that may fairly be regarded as typical of or broadly incidental to the enterprise undertaken by the employer. Holding that corporation could be liable for statements made by the plaintiff's supervisors and co-workers about the plaintiff's falsification of a time card and alleged threats of, see that court case cited. Holding that employees' defamatory statements made at work, about work, related matters were within the scope of their employment for purposes of respondent superior under California law, again, see that court case cited. Finding that an action is within the scope of employment when in context of the particular enterprise, an employee's conduct is not so unusual or startling that it would be seen unfair to include the loss resulting from it among other costs of the employer's business. Citations and internal quotation marks were omitted. Continuing to read this, it says, as alleged in the FAC, the Sloan parties made a series of defamatory statements about the Wayfarer parties within the scope of their employment agency. As to Baldoni, the FAC alleges that the Sloan parties made statements to third parties, including without limitation to the NYT and other news outlets, to the effect that Justin B. is a predator who SA'd Blake Lively, and that Justin B. retaliated against Blake Lively and others for reporting the alleged misconduct, including by propagating false and misleading narratives about Blake Lively for the purpose of damaging her image and reputation. The Sloan parties also made other false statements in response to media inquiries concerning Blake Lively's wrongful accumulation of power over the production, the means by which she did so. Example, false accusations of misconduct and the resulting turmoil. Although not in an employment relationship, Ryan Reynolds, too, was acting as Blake Lively's agent when he defamed the Wayfair parties. As alleged on at least 2 occasions, Ryan Reynolds stated to executives at WME, Justin Bieber's and Wayfair's talent agency, that Justin is a predator. Reynolds knew, as the jury will know, that an accusation of this kind renders the target persona non grata. By referring to Justin Bieber as a predator, Ryan Reynolds attempted to render untenable any continued ties between WME and Justin Bieber with the Sloan parties, who made similar defamatory statements to the press. Ryan Reynolds was part of the campaign to destroy Justin Bieber's reputation and career. I am going to pause reading part 2 at this point, and we will continue to dig into this really explosive filing from Justin Bieber's lawyer, and we're definitely getting into more of the more interesting parts of this. Make sure you guys like, share, and subscribe. Thumbs up this video. Part 3 is coming shortly. Bye, guys.